Good morning. Last time I talked to you, I promised to bring a new tool for the legal process, the court process, and I wanted it to be something that is simple, which would undergird a trial which would be short, decisive, and not puzzling. So what we're going to do is build on a familiar foundation. We'll take the ordinary, what we call a civil trial, like an auto accident or suit about a business matter, not a criminal one. Use that as the base and just change what we call the standard of proof. So with the ordinary business case, something like an auto accident or dispute about business, we have very simple structure. We have a standard of proof, which is as low as you can get. It's called the preponderance of evidence, or it's called 50% plus a feather, or more likely than not. Basically, it's just like tossing a coin, but saying it's a little higher. And the statisticians would call that non-parametric evidence. And it's harder to build up a decisive indication that what your decision is right. So we're starting at a low level. And with the business case, you win if you have 9 saying yes and 3 saying no. And we're going to go to the criminal case, and I'm going to have exactly the same structure, except we'll do a different standard of proof. And with criminal cases, the standard of proof is very high. You say the defendant is guilty beyond a reasonable doubt. Beyond a reasonable doubt. That's quite high. The statisticians would say that this had a 0.95 probability of being correct. And if you discount that down to 0.9 because it's an instruction to the juror how to think about it, and instructions get only partly passed along, but it's a really pretty high standard. Something, if someone says that, you have a strong reason to believe what they say. They really looked at it. They looked at what it could be one way or another, things that were not clear, and they really are saying, this is pretty clear, this is solid, we can count on it. So we have 9 votes with this clear one point, and then the other 3, all you know about them is they're somewhere below that standard. They could say, oh no, the guy's innocent, or they could say, well, a little more likely than not, or a little more likely to be innocent. So it's not, doesn't change it. So the statisticians would indicate this has a very low p-value, namely the possibility that this conclusion is wrong is very, very low. So that's very solid. Now, one thing about it, you have this 9-3, and the trial scheme that got us in trouble is going past that 9-3. And as a matter of fact, they said, really, it's got to be 12-0. And that made it very, very hard to win a case. So it made it very unwieldy, and something that a prosecutor really, on an honest basis, would not want to have anything to do with it. Why would you get into something where it's almost impossible to get the number of votes to win? And so the prosecutors correctly fought this. It was overbearing, it was stupid, and it's something that doesn't work. So my solution to this is to stay with the 9-3. Do not make it 10-2 or 11-1, or as was done in the case we're talking about, was originally 12-0, and then a lot of weird stuff. So that's it. That's what I want. I want in all the states and the federal government too, to be the new way that cases are tried. This avoids the absurd difficulty of getting everybody in on it, and it's very solid, so 9-3 is perfectly enough. And so that's the lowest standard, and it should work for both. It should be very fast, very clear. You have your trial. You have the jurors talk to each other for a while, more to just be in phase with what it does in setting sentences on another human being. It's not that easy. So it's good for people to talk a while, not too long. The problem with the old method is that they rely on people talking a long time and of becoming polarized into two groups, and then by some strange magic, they would have the two groups go in one way or the other and aim for either a unanimous 12-0 for a conviction or a unanimous 12-0 for acquittal, this on the federal government, others variation. So what I want to do is simply get this new tool, which I think will be solidly accepted by both sides, a great improvement over what's there. And when we have this okayed, then in the next session, we'll sit down and see what can be done with it. There's a way that I absolutely want, but there are other ways of dealing. So let's just consider this our new tool, and we'll meet again and we'll see how it can be used. See you then.